Did you know that? Did you know it can be a federal offense to be in possession of a lobster? Admit it. Raise your hand if you did not know that. There's the problem. And that's only one of 10,000 different ways. You know, the government gets pretty upset when people like me instructs the client, people like me and Justice Jackson, don't talk to the police, don't answer any questions. But you know, they can't have it both ways. You people, you've got 10,000 different ways of convicting us. Good for you, but you know, with the bitter comes to the sweet, with the good comes to the bad. That's 10,000 different ways my client might unknowingly implicate himself in some sort of a criminal transaction. One of the reasons I decided to give this talk, I recently received a phone call from a former student of mine, a regional law school graduate, who may be watching this online. We're putting it on the internet. And he told me, hey, I've been approached by the Internal Revenue Service. They want to ask me a couple of questions. They ask if I'd be willing to. But they say that I'm not a suspect. And I know in my heart I don't think I've done anything wrong in violation of the Internal Revenue Service provisions. Lord have mercy. There's no man on earth, there's no woman in this country who can honestly say with complete confidence, I know I have never violated any provision of the Internal Revenue Code. He said, but they say I'm not a suspect and I know I've done nothing wrong. It's okay if I talk to him? I said, no, you tell them you will not talk to them without immunity. I explained to him why that was true, and he never heard from them again. Okay, why you should never talk to the police. Let me just spell it out for you. Let me make it plain to all of you. These are the top 10 reasons. I shouldn't really lie to you. I don't really have 10. I don't have time for 10, but I've got time for 8, and that'll be close enough. Number 1, and this really ought to be good enough. Contrary to what you laymen instinctively and naturally suppose, it cannot help. There is no way it can help you. Plenty of folks think that it can, and they're always wrong. You cannot talk your way out of getting arrested. Officer Brook, you've interviewed thousands of criminal suspects. Have you ever, how many times in your experience, have you approached someone, asked if you could ask him some questions because prior to the interview you had some evidence pointing to his possible guilt? And because of the extraordinary persuasiveness and eloquence with which he articulated his innocence, you said, oh, sorry, never mind. Bad call, my bad, I won't. And he talked you out of arresting him.
You know the answer to that.
Never. It never happens. I've often asked other criminal defense attorneys, in all of your experience, have you ever once had a case where you looked back in hindsight and said, thank God my client talked to the police? They laugh at me. They say, you've got to be kidding me. You cannot help you. You can't talk your way out of getting arrested. And contrary to what you might suppose if you never studied the rules of evidence, what you tell the police, even if it's exculpatory, cannot be used to help you at trial. Because it's what we call hearsay. Under the rules of evidence, specifically Rule 801D2A, if you want to look it up, everything you tell the police, as the saying goes, can and will be used against you, but it cannot be used for you. From time to time, I've known attorneys who tried to call to the stand a police officer and say, officer, would you tell the jury what my client told you because what my client told him was actually good for my case? If you tried that at trial, the prosecutor will object that it's hearsay, and the judge will agree. The police will not be allowed, at your request, to tell the jury what your client told him, no matter how good it may be for your case. It cannot help. And that ought to be good enough reason. That ought to be reason enough to keep your mouth shut. But if you're not persuaded, let me go talk about a couple of others. Number 2, obviously one of the most obvious. If your client is guilty, as many of them are, but even if he's not, even if he's innocent, he may well admit his guilt with no benefit in return. Now, of course, many of you are thinking to yourself, well, what's so wrong about that? I mean, shouldn't guilty people be confessing? Confession's good for the soul. It's good for law enforcement. It's good for the prisons. Yes, sure, all those things are true. And like the rest of you, if I or anyone close to me is ever the victim of some sort of a serious crime, I hope they get the right guy. I hope they convict him. I hope they put him away. We all feel that way. Hey, but what's the rush, friends? You don't got to admit your guilt the first time they come by to meet with you. In federal court, 86% of all defendants plead guilty at some point before trial. If your client is guilty and really ought to punish and really ought to have go through some sort of a cleansing act of contrition and fess up and admit his guilt, there'll be plenty of time to do that. They almost always do. No need to rush, no need to tell the police something. Wait and see if perhaps your client can work out some sort of an arrangement where maybe he'll make some sort of compensation to the alleged victim, or maybe he'll be able to get some sort of a discount in his sentence. And he'll be treated fairly then, like everybody else who had the benefit of a good lawyer who said, please do not talk to the police. And don't forget, by the way, even if your client only admits things that the police already knew, you might think, well, what harm can it do? He says he wants to talk to the police. All he wants to do is admit that he was there, but the cops know that he was there. All right, go ahead and tell him. Well, how can it hurt? It might hurt if the police officer becomes transferred to Minnesota, or deceased, or injured, or comatose, or cannot be located by the time of trial. The case will be dismissed if there's no confession. But if your client admits 2 things, that confession is freely admissible against him and can be a basis for getting him convicted all by himself. Senator Larry Craig can explain all of this to you. The Innocence Project of the United States has confirmed that in more than 25% of all the cases where an innocent man was convicted and then later released from prison after he was exonerated by DNA evidence, in more than a quarter of those cases, these innocent people we know to be innocent, made incriminating statements, delivered outright confessions, or pled guilty. How do they do that? He'll tell us all about it, I trust. Here's a couple of famous examples. You can just ask them. You don't have to take my word for it. There on the left was Eddie Joe Lloyd. He was convicted in 1984 of the murder of a 16-year-old girl in Detroit after he wrote to police with suggestions on how to solve various recent crimes. During several interviews, police fed details of the crime to Mr. Lloyd, who was mentally ill. And they lied to him and convinced this mentally ill man that by confessing, he might help them smoke out the real killer. He later signed a confession. It gave a tape-recorded statement. The jury deliberated less than 1 hour before convicting him on the basis of this confession. There was no other substantial evidence against him. The judge said, I'd hang you if I could, but the death penalty was not available in Michigan at the time. But after almost 2 decades in prison, he was released after DNA evidence proved that this man was innocent and had falsely confessed to a crime that he did not commit. On the right is Earl Washington, who was released from prison just a few years ago here in Virginia after spending 18 years behind bars after being committed of a rape and a murder that we now know he did not commit after having been exonerated by DNA evidence. But this man, Mr. Washington, who was in fact confirmed to be mentally retarded, was able to confess to several crimes at the request of the police, some of which we know he could not have committed. That's the problem. Some of you are thinking to yourself, well, none of this concerns me because I'm not guilty of anything and I never will be and I will never represent people who do. Okay. Let's talk to you people. You innocent folks. Those of you who have never committed a crime and never will, and none of your clients will either. And you wouldn't go out with a girl who did. Fine. You better not talk to the police either. Okay? Because number 3, we'll put the guilty behind us. Forget about them. Let's talk about innocent people. Number 3, even if your client is innocent and he denies his guilt and almost entirely tells the truth, odds are good he will easily get carried away and tell some little lie or make some little mistake that will hang him. This is human nature. He gets in there, it's a stressful situation. Imagine a perfectly innocent client. The police say he's been guilty of a murder. He's totally innocent as any one of us. So he goes in there and he meets with the police. He says, I don't know what you're talking about. I was nowhere near there. I didn't kill him. I've never killed anybody. I don't have a gun. I've never had a gun. I've never touched a gun in my life. I was nowhere near Virginia Beach that night. That last line was a lie. He went over the top. He was getting carried away. He got into this groove. He started saying all kinds of things, almost all of them true, that he knew would tend to exculpate himself. Then he got carried away and just said one thing that wasn't true, and unfortunately for him, they can prove that it wasn't true. He may be convicted on that basis alone. But let's say, well, that's not a problem. I'll tell my client only to tell the truth. I've met with him. I know he won't lie to the police. He won't make any mistakes. Okay, that's still no guarantee you won't be getting into trouble. Because even if your client is innocent and only tells the truth and doesn't say anything that is false. Now, already, mind you, we're pretty well nigh into fantasy land. The odds of anybody being able to pull this off are really quite slim, no matter how innocent they may be. But just the same, let's pretend. Let's assume he gives the police nothing but the truth, and he is totally innocent. He will always give the police some information that can be used to help convict him. Always. For example, suppose you tell this to the police. Here's what your client tells to the police in his denial of guilt. I don't know what you were talking about. I didn't kill Jones. I don't know who did. I wasn't anywhere near that place. I don't have a gun. I've never owned a gun in my life. I don't even know how to use a gun. Yeah, sure, I never liked the guy, but who did? I wouldn't kill him. I've never hurt anybody in my life, and I would never do such a thing. Let's suppose every word of that is true. 100% of it is true. What will the jury hear at trial? Officer Brook, was there anything about this, your interrogation, your interview with the suspect that made you concerned that he might be the right one? Yes, there was. He confessed to me that he never liked the guy. And then the prosecutor will put that up in big letters and he'll say, ladies and gentlemen of the jury, it's pretty clear that we've got the right guy here. We've proven that he was in Virginia Beach that night. That's opportunity. And remember, Officer Brook admitted that after extended questioning, he was finally able to get the defendant to admit that he never liked the guy. There's your motive. Motive plus opportunity. Wham, bam. Please. But juries eat it up. And innocent people get convicted this way sometimes. How often? Hopefully not too often, but we know what happens. The United States Supreme Court, don't take my word for this. In Ohio versus Reiner, the Supreme Court of the United States said, quote, one of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government with incriminating evidence from the speaker's own mouth. See, it's not just some criminal defense attorney telling you this. Even the Supreme Court says I'm right. Under the facts of that case, by the way, in Ohio versus Reiner, a child tragically was died, apparently the result of shaken baby syndrome. Question was who had shaken this baby to death. And one of the possible suspects was a babysitter who had spent some time with the child that week. The babysitter's story was, I don't know what you're talking about. I did not kill the child. I did not see it happen. I don't know who shook the baby. It was never me. I never did anything of any violent nature to the child. The Ohio State Court said, well, you've got no Fifth Amendment privilege. You, by your own admission, told the investigators that you've done nothing wrong, that you were not involved, so obviously your answers can't incriminate you. The United States Supreme Court reversed and said, well, that's not true. Even though this babysitter denies shaking the child, denies seeing the child die, denies knowing how the child died, this babysitter, by her own admission apparently the government wanted to ask whether the babysitter might have been with the child at some point that week, during the week prior to the death. And that answer, although by itself not sufficient to convict anybody, could help convict her. That means she's got a Fifth Amendment right to refuse to answer to the question the court held, because it could be used to help convict. Ullman versus United States, which the Supreme Court said more than 50 years ago, eerily prophetic. They said too many Americans, even those who should be better advised, view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of crime or commit perjury in claiming the privilege. That's not true, and it never has been.